Can I open a business and sponsor myself for PR? There are many temporary visa holders with successful businesses such as restaurants, disability care providers, or trades like mechanics or floor finishers. And it can be hard to find an employer committed to sponsor you. So I often get asked, can I sponsor myself? It's a difficult question. Hi, I'm Chris Johnston from Work Visa Lawyers. We've been helping people with employer-sponsored visas since 2011. We've helped with thousands of employer-sponsored visas over the years. Please subscribe to our channel to receive the latest updates and immigration news. The employer-sponsored 482 visa has become a vital pathway for skilled workers seeking employment in Australia. The visa requires a sponsoring employer to nominate the applicant for a specific role. We often get the questions about self-sponsorship. But is self-sponsorship for a 482 visa a viable option, or is it bound to be refused? Let's explore this question. And now it's not only just about the 482, but now it's very popular to do a direct entry 186 visa, which is straight to permanent residency. There's now 456 occupations on the core skills occupation list, which you can apply directly for a 186. So what is self-sponsorship? Self-sponsorship refers to the scenario where an individual owns the business and wants to use that same business to sponsor themselves for a 482 visa or for a 186 visa for permanent residency. We're going to go through an example based on a 482 temporary work visa. This approach involves the usual steps of a 482 visa, which are the following. There's 3 steps. Firstly, sponsorship approval. The business must apply to become an approved sponsor through the Department of Home Affairs. The second stage is nomination. The business must nominate a position that aligns with the applicant's skills and that's on the relevant skilled occupation list. And then visa application, the third stage. The skilled person applies for the visa application, proving qualifications and work experience, English ability, and in some cases they might need a skills assessment. And there's also health and character requirements. We've just gone through some of the 482 visa requirements. The Department of Home Affairs has specific requirements for businesses sponsoring a 482 visa applicant, whether they are self-sponsored or not. These requirements include genuine need for a position. The business must demonstrate that they have a genuine need for the role within the operations. Market salary. The nominated position must meet the Australian market salary rates to ensure compliance with Fair Work standards. Labour market testing, or LMT. In most cases, businesses are required to prove that they have advertised the role locally and were unable to find a suitable Australian citizen or permanent resident candidate. Financial capability. The sponsoring entity must have sufficient financial resources to support the employment of the visa holder. So what are the big challenges of self-sponsorship? While self-sponsorship is theoretically possible under the current visa regulations, it faces some significant challenges. Number 1, proving the genuine need. The Department of Home Affairs scrutinises self-sponsorship applications much more closely. Proving a genuine need for the position can be difficult if the business is newly established or lacks substantial operations. For example, if the applicant is the sole proprietor and the only employee, the department will have many questions and it may be difficult to be successful. Number 2, labour market testing requirements. LMT requirements require the advertising of the role and proving no suitable Australian candidate could be found. This can be challenging in self-sponsorship cases, and it may appear that the role was tailored specifically for the applicant and that it wasn't advertised properly. Number 3, financial viability. Some people may establish a new business to try sponsor themselves. A newly established business may struggle to provide evidence of financial stability, such as cash flow statements, tax returns, and contracts. Without these, it becomes challenging to demonstrate that the business can meet the sponsor obligations. A 4th requirement, perception of conflict of interest. Self-sponsorship inherently involves a potential conflict of interest as the applicant is both the sponsor and the beneficiary. This can raise the concerns with the Department of Home Affairs about the integrity of the application, and the elements that undermine genuine position and labour market testing may become problems. So, is it possible to have a successful self-sponsorship application? While it's challenging, self-sponsorship is not impossible. Applicants who are determined to pursue this pathway must consider the following. Have a comprehensive business plan. Develop a robust business plan that outlines the operational structures, revenue model, and market opportunities. Highlight how the nominated position is essential for the business. Even for established businesses, a business plan or a letter from an accountant can be very helpful to demonstrate the need for the position. Independent validation. Engage a third-party professional such as accountants or business consultants to help validate the position of the business. This creates a degree of separation so that claims can be made not just from one person. Transparency in labour market testing. Conduct genuine labour market testing and maintain detailed records to demonstrate compliance. For self-sponsorship circumstances, it is even more important that a full evidence, including a candidate matrix of who apply for the position, are provided to the Department of Home Affairs. Seek expert advice. Immigration lawyers or registered migration agents can provide valuable insights which may lead to a better quality application if you're in a self-sponsorship scenario. So let's talk about some real cases. One that was successful and another that was not successful. Let's start with a successful story. This is a matter reported from the appeals body, the AAT. The name of the case is on screen. It involves a business called Project 42 Pty Ltd. In this case, Project 42, whose nomination for CEO and Managing Director for a multimedia consulting company was refused by the Department of Home Affairs. The case highlighted that there is no rule precluding self-sponsorship, but that there are strict requirements to maintaining the system's integrity. The business had 6 staff, including events manager, video editor, office manager, graphic designer, public relations and social media managers. The position to be filled closely matched the nominated occupation. The tribunal member was convinced that the position was genuine and that proper labour market testing had been done. And now let's talk about a refusal example. Again, it's from the Administrative Appeals Tribunal. This involved Sarab Trading International. In this tribunal matter, Sarab Trading International Pty Ltd were not successful in sponsoring the manager who was the owner, director and the only employee. The ANSCO occupation selected was 134999, Specialist Manager NEC. The tribunal member did not find that this occupation was likely to be appropriate and was highly specialised occupation that did not match well with the role within the business. The business was an export business. The business only had one employee, the person nominating themselves. The tribunal found that the nominating position was not genuine. However, in this case, the strict integrity requirements, namely the requirement to prove genuine sponsorship, meant that the nomination was not successful. So what's the difference between the two cases? What makes the difference is the evidence that can demonstrate there's a genuine need for the role. In the successful story, that business was able to show more evidence that they had done genuine labour market testing and that they had a genuine need for the position. Decision makers will consider all aspects of the position and the business to determine if it appears to be a genuine arrangement or if the application seems to have been contrived to get a migration outcome. So if you have a business and you want to do self-sponsorship, will it work or will it be refused? The short answer is that on many occasions, opening a business and applying for self-sponsorship will not be successful. This is due to concerns about the genuine nature of the position and labour market testing. But there are circumstances where self-sponsorship could lead to a viable application, particularly with larger businesses where the genuine need for the position is able to be demonstrated. So the safest path is to find a business that you do not own that can sponsor you. But we know this can be hard to find a sponsor. We have a video on how to find a sponsor and there's a link in the description below. Self-sponsorship for the 482 visa is a highly risky pathway. The application requires that the position being put forward is a genuine position and that it's not made for migration purposes. Further, there needs to have been thorough labour market testing done. But on some occasions, a successful business has been grown by a visa holder and they may hold a management level position in the business and may be qualified to manage the business, and in such circumstances, they may be successful. We will generally warn people to be careful about self-sponsorship because there's always a risk of rejection. For those considering self-sponsorship, the key is preparing a strong application with plenty of evidence. With a good case, self-sponsorship can be done, but it's a risky application. If you'd like to know more about this, you can book an appointment with one of our registered migration agents or immigration lawyers to discuss your business and your future. Subscribe to our channel for more Australian visa updates. Thanks for watching.